Welcome to today's webinar. Give me just 1 second, I'm finishing my haircut. Wait a minute, I can't cut my hair with the stapler. That would be useless. You know what else is useless? Having an estate plan that doesn't work, or having no estate plan at all. It's useless to cut your hair with the stapler, and it's useless to have an estate plan that does not work. So we are so glad that you joined us here today. We're going to have fun, and I promise you, you will learn something new and important. If you want to make sure that your life savings goes to the right people at the right time and not to the wrong people or at the wrong time, then this is definitely the place for you. So glad that you've joined us. Hundreds of people I've talked to, clients and others, have told me that they have delayed and procrastinated their estate planning. When I ask why, they namely say it's because of anxiety. They're anxious about thinking about death. I get that. They're anxious about thinking about who they would name as their agents, their executor, who they want to leave their money to, or maybe a little bit of money to. And they may be anxious about just spending the time and taking the time and spending the money to do it. And some people are anxious about their child decision there, who they would want to raise their children, their minor children, if something happens to them. I get that. That's a hard thing to think about. But the best thing is to get a plan in place, and we can always change it. Just about everything we're talking about today is revocable and amendable. We can make new documents at any time as long as you have capacity and you're still alive. So it's not like it's set in stone. We can change just about every document that we're talking about today. So go ahead and get a plan in place. And what we do at Massey Law is we help put away that delay and procrastination and anxiety because we have a process that's quick and efficient but very effective. And you'll see throughout today's presentation how we do that, why we do that. Our life has a lot of highlight reels in it. We may look at the high school highlight reel or college highlight reel or when we got married or the birth of a child or children. Just some amazing events. But there's also some sad things that happen in our lives. Recently, many of you watching this and me, I've known people who have passed away from COVID. Recently, I've had a few friends commit suicide over the past 2 or 3 years. Many of us have had friends and or family have cancer. Some have passed away, some have survived. Very real for me is in 2012, we had a daughter pass away, full-term birth. About 2 years ago, we also had another child pass away, a son, 15 weeks pregnant, and my wife delivered him. So I get it. I get death, but we're not promised tomorrow. We are here today, but life is but a vapor that is here today and gone tomorrow. And we don't know if we're going to live to be exactly 76.2 years old with 1.5 kids and a white picket fence, because it doesn't necessarily play out that exact way for most people. And if you're one of the people who don't really know when you're going to pass away, then you should pay particular attention to this. If you know exactly when you pass away, maybe this webinar is not for you. But we're excited that you've joined us. We're going to have fun. We're going to learn. We're going to talk about wills. We're going to talk about trust, some of the pros and cons of each. We're going to talk about blended family situations, kind of think Brady Bunch, husband, wife, remarried, kids from a prior marriage. Estate planning is particularly crucial for blended families. We're going to talk about kids getting money too early and it actually destroying their relationships and or their lives. We're going to talk about an LLC, and for some people, their value, their goodwill can evaporate almost overnight when they pass away if they don't have proper planning in place. What if your children fight over belongings or whether you wanted to be cremated or buried? We're also going to talk about the number one mistake that I see that forces probate in regards to home ownership. Whether you're married or you're single, this applies to you if you own a home. So we're going to have a lot of fun. All right, intestacy. Intestacy, when you die intestate, you die without a will. So there's problems with that. The first is that you may not have an estate plan, but the state of Texas has one for you. But you might not like it. Also, it's more expensive. So our court costs and the courts that we deal with are higher when you pass away without a will than when you have a will. Our attorney's fees are higher when you pass away without a will than when you have a will. Why? Because it's a more complex and arduous process. It's more time consuming and it costs more money. It takes more of our time. And that means it takes more money out of your estate. And some of the bigger issues too is, especially if you have a blended family situation or if you have separate property or something like that, your spouse may not get your assets because some or a lot or all of those assets may actually pass to different people. So for example, you have a $2 million estate. Let's just assume it's all community property, and we're not going to go through the intricacies of community and separate property, doing a 50,000 foot broad stroke. Let's just say it's a $2 million estate, $1 million husband, $1 million wife. Husband has kids from a prior marriage. He passes away. Let's assume that $1 million, because of state law, goes to his kids. So now the surviving spouse is left to live on half of the income, half of the assets that she had prior. That is a dire situation for many of you watching this, and it's something that you don't want. So you need to plan, and we'll talk about some of those opportunities here later on in the webinar. What if you pass away without planning, your kids are 8 and 10, and they inherit between your assets and life insurance $1 million each that gets released to them when they're 18 years old? How do you think your 18-year-old is going to handle $1 million? There could be no problems with peer pressure, substance abuse, gambling, or bad decisions, right? Whatever. All right, let's go on to probate. But before we get to probate, let's take a look at this. These are keys. You can't take them with you, but someone may want the key to this. Someone may want the key to this. Someone else may want the key to this. Since you can't take it with you, it means it gets left behind. How are you going to have that distributed? Who's going to distribute it? Who's going to potentially fight about it? Let's talk about that stuff, okay? Now you're going to see me do some goofy stuff. I'm going to wave my arms and do some funny facial expressions and bring up some props. And the whole purpose of that is to help you stay engaged, because this is crucial. This is important. This is estate planning that is talking about your life savings and your legacy. So I want to make sure you pay attention. So we're going to get a little goofy, okay? Please forgive me. Probate. That's a process whereby your executor hires an attorney and takes your will before a judge in a court of law to get letters testamentary so that they can go out and collect your bank account, investment accounts, home, and distribute it in accordance with your will. Okay? The probate process in Texas is fairly benign relative to other states. In the courts and jurisdictions that we tend to represent the most, I would say that our typical attorney's fees and court costs combined are probably $3,000 to $4,000, give or take maybe $1,000 or two. That is much better than a lot of states. A lot of states you're easily into the five figures, $10,000, $20,000, $30,000. And the time process, I would say that most of the jurisdictions that we're in are probably 2 to 6 months before you get letters testamentary. In other states, that may be 6 to 12 months or 18 or 24 months. So you may be thinking, I'm a Texan. It's not a terribly expensive process, but remember that happens each time a spouse passes away. So you could be talking $3,000 to $4,000 each time a spouse passes away. Unless you want to do better planning, that's going to happen. Or if you die without a will, then it's going to be even more expensive and time consuming than that. But what if you don't live in Texas when you die? What if you moved and you failed to update your plan? You didn't want to update your plan. What if your kids moved? They wanted you to be closer to them, but you're in a nursing home. You don't have the capacity to update your documents, and now you're in that other state, and it's going to be more expensive and time consuming, say in California, Colorado, pick a state that is most likely far more expensive and time consuming than ours, but you'll have to do your own research on that state. So these are the things we want you to think about. Also, the probate process is a public process where anybody can look at your documents and look at your assets of inventory and figure out, just nosy neighbors, nosy family wanting to know more about you. Or a fraudster trying to figure out who they're going to target as their next victim, or a hackster or something like that. It's kind of like if you think of in the old days, they take that clothesline and put the clothespins, they put their socks and their shorts and their drawers. And you don't want people looking at your drawers. So a lot of people just don't want their stuff being aired in the public arena. They'd prefer privacy, so they'd prefer to avoid probate. Maybe you don't mind that, but I've talked to a lot of people who just say, you know what, I'd rather stay out of the public purview. Let's just try to make this thing stay out of probate, okay? So there's a lot of things to think about in probate. It's not entirely bad. There's pros and there's cons. We can help walk through and see your particular situation, what that might look like. You can do your own will online. There's some pretty good programs out there, and they'll do the Q&A and interview and whatever it is. But that doesn't mean you're going to have all of your bases covered. I have so many people who come into me who have done their own planning online, and we need to correct it. Some of the common mistakes I see. One, they did their will, but they didn't realize that there's a good chance that they could avoid probate if they did X, Y, or Z. And we can show them how to do that and potentially save $3,000 or $4,000 upon each of the spouse's death. What else do we see? Oh, we see people who print documents, but it's hard to get them executed and signed properly because you need 2 disinterested witnesses and a notary. So people just say, I'll figure that out later. I've got my documents, boom. And they never do it. So they literally come in, plop down wills on my desk that have never been signed, which means they're absolutely useless. We can shred them, make a paper airplane out of them. They're as useless as cutting your hair with a stapler. We also see people who do their documents, they sign them, but they didn't have them witnessed, or they didn't have them witnessed by a disqualified or a disinterested witness. So maybe they had their child, for example, as their witness. You can't do that, okay? We need to think through these things. We do this all the time. We want to help you. And when you just do a will yourself every 10 or 20 years online, there's a good chance you're going to miss something that's important. But hey, it's only your life savings. You only had blood, sweat, and tears for 30 or 40 years. Who cares if something goes wrong, right? And by the way, many of you watching, probably all of you, recognize this symbol, Starbucks. And many of you will go out and spend $4 or $5 a day or several times a week at Starbucks. Well, $4 a day, if you do that every day of the year, that's over $1,000 a year. You can afford good estate planning, okay? I promise. If you drink Starbucks or another coffee, I'm just making an example. I love Starbucks. I drink Starbucks too. But I also have my estate plan in place. If you drink Starbucks or another company like that, eat out a lot, then you can probably afford estate planning. We want to help you. And we can help you if you have 6 figures, 7 figures, 8 figures. Call us. Let's talk through it. Blended family situation. Got the Brady Bunch. We kind of fleshed that out a little bit. So let's talk about a couple situations. So husband says, okay, I watched your webinar. I don't want to die without a will. So I got a will and I named everything going to my spouse. So now my spouse is going to have all $2 million of ours. No problems with that, right? Well, what if spouse gets remarried and she does a joint will with her new spouse and she cuts out his kids so they get nothing? That's not a good situation. So he watched this webinar and he said, okay, I'm not going to give it to my spouse. I'm going to give it to my kids, and I'm going to tell my kids to take care of stepmom. So they get the $1 million of his, she keeps $1 million, and they start giving money to stepmom, but then something happens in the relationship. Now, I don't think that's possible, right? No one ever has a problem with an in-law or a step-parent or a stepchild, right? That could never happen. Absolutely it could. And so they just say, you know what, stepmom, we're done. We're not giving you any more money. And they have the right to do that because at that time, it's completely their money. So he watches the seminar. He says, hey, I'm just going to give it to my spouse. And I'm going to say, spouse, honey, I love you. Make sure this, whatever's left, goes to my kids when I die and not to your kids or not to your next spouse. And she says, sure, honey, you can trust me. I call this the trust me situation. And she has every intention of doing that, but then she gets remarried and accidentally just leaves it to her new spouse, or she has a fight with the kids because the kids say, her stepkids say, I don't want you to see the grandkids anymore. I'm cutting off your access. And she says, wait, you make me sad, so I'm going to get revenge, and I'm cutting you out of the estate. And they get nothing. And there's nothing they can do about it because it's her money at that point in time. Do you see where I'm going with this? Blended family situations are crucial. We'll talk about one potential solution a little bit later in the webinar, so stay tuned. Let's go. Powers of attorney. A power of attorney says if you become incapacitated, who gets to make certain decisions for you? Now, some people say, I don't really think I'm going to be incapacitated, but let me share some situations so that you have a better grasp for what this may look like. Let's say you have a stroke. I actually have someone close to me who is my age and had a stroke. What if you have a heart attack? I've had several friends my age have heart attacks. Some have passed away. Some have survived. What if you have COVID and you can't make decisions? What if you have a car wreck, head trauma, Alzheimer, dementia, something like that where you just can't make the decisions anymore? Who's going to make the decisions? If you don't have this established, properly, validly executed, with the right people named, it could spell trouble, because now people could fight over who gets to make that decision. Courts could have to get involved. That becomes expensive, time-consuming. Maybe the court appoints someone that you don't trust. You wouldn't want managing your finances. You wouldn't want making medical decisions for you. So these documents are vital. For a durable power of attorney, you could do a short form, which is like a 1 or 2 page, or a long form, which is like an 8 to 12 page document typically, and it really spells out paragraph by paragraph. Here's the responsibilities, duties, and privileges that my agent can do on my behalf as they act in my behalf. So, an example. For me, my power of attorney, it may say my wife has the ability to make these decisions now, even while I have capacity. But if I don't have capacity and she's not available, deceased, incapacitated herself, then it goes to, say, my brother-in-law to make decisions for me. And then to, say, my parents as co-agents. You can make co-agents as well. I'd encourage you to name someone who's honest, trustworthy, and has proven to be financially and fiscally sound in their own money management and wealth management. Because if they don't have those qualities, then I wouldn't trust them with my life savings. And who's going to, if there's no one named, who's going to be able to pay your bills, pay your rent, pay your taxes, help your kids with money, sell your home if necessary? All of those are vital. And then a medical power of attorney does the same thing, except who gets to make medical decisions for you and tell the doctor what to do. Now, your power of attorney, durable power of attorney, and your medical power of attorney, the agents may be different. Over here, you may say, it's my brother. He's trustworthy, he's fiscally sound, he's made his own money, I trust him there. Over here, it's your sister, because sister's not as good with money, she doesn't make much money, or she lost money in bad investments or something, but she's a sweet, caring person. Maybe she's a doctor and really closer to kind of knowing medical terms and stuff. So they can be different people. So hopefully now you have a better grasp to begin understanding the powers of attorney, the importance of it, and we would be honored to have that conversation with you. Write this down. It's bit.ly/free15 now. We are offering you a 100% free, that means $0, no obligation, phone consultation to get to know you, to discuss what's going on in your estate planning needs, to see if we're a good fit for you. We may or we may not be. To see if you're a good fit for us. You may or you may not be. So we kind of interview each other on the phone. All you need to do is go and book that appointment. It's absolutely free. Let's get to know each other, see if we want to move forward in helping you with your estate planning. Kids' powers of attorney, they work very similar to adults' power of attorney. So here's an example. You and your spouse go on a vacation, maybe an anniversary vacation or something to Paris, just the two of you. You leave the kids at home, but you can't get back. Think COVID. Right before COVID, everybody's like, I can't think of a situation where I may be out of pocket. Well, you're stuck. You're in Paris, you're in Africa, you're in South America, I don't care where, Mexico, and you can't get back. Flights, disease, something like that, you just can't get back. So who can make decisions for your children? If they get hurt, who's going to be able to give the doctor's orders of what to do and not to do? Well, this document says this person, these people, get to make those decisions on my behalf if I'm unavailable. Maybe you're just in San Francisco and you got in a car wreck and you can't get back to Texas because you're in a hospital bed for a couple of weeks and someone needs to take action on behalf of your child. And the other document says, for example, it's got a lot of things listed out, but one thing is who can enroll your kid in school and pick them up from school, right? Because you can imagine this dude comes rolling up to your kid's school and says, "Yeah, I'm here to pick up little Johnny." And the teacher says, "Who are you?" And he says, "Well, I'm the guy with the black van over there with no windows, and I'm here to pick up little Johnny." And she's like, So we have a document in place that says, here's the people that can do these sorts of activities if we're unavailable. It's very important, all right? So I tell a story there just to kind of illustrate, and again, to kind of keep your interest, because this is important stuff, vital. So let's keep going here. Let me show you something. You know what these are, and you know what this is. And I'm going to stop right there because I don't want to cut off my finger. That would not be a good idea. And you should not want to have no estate plan in place, because that's not a good idea. Or to have an old and stale estate plan. That is not a good idea. I don't want to cut off my finger, and I don't want you to have a bad estate plan. So call us. We would love to speak with you. Setting up beneficiaries for failure. So money can actually destroy people. I'm pretty sure you've witnessed this in your life at some point, where money literally destroys people. So imagine that 18-year-old getting $1 million. Nothing could go wrong, right? Yeah, right. So they get $1 million, and their buddy's like, "Hey, let's go to Vegas. Again, we got fake IDs. You bought them for us. Let's go drink some more. Let's go do some more drugs. Oh, and you're paying. Let's invest in this business, because that child's 18 years of age and certainly knows how to invest in a business. It couldn't go belly up, but it does, and they lose everything. Peer pressures, or they get married, say at 18 or 22, right after college, commingle their assets, it's all joined, and then they get a divorce. And she takes a portion, maybe half. We're not going on community or separate property law. This is not family law. I'm just giving you some ideas of some things that you want to think through when it comes to your estate. It's your estate, your life savings, not mine. My plan's in place. Is yours? All right, blended family subtrust. So one of the solutions to that Brady Bunch situation is, instead of husband giving his money to wife, instead of him leaving money to his own kids, he leaves it in this subtrust. There's different names for it. There's marital deduction trust. There's Q-tip trust, Q-tip with Clayton, all sorts of stuff. But primarily, I should say, it functions like this. His money goes here, and it gives him money income for the needs of his spouse, of these kids' stepmom. But whenever she passes away, this money then goes to his kids, or maybe to both of their kids. But she can't come in and change the beneficiary. She can't take it away from those kids. She can't name a future spouse or just her kids. Those beneficiaries are locked at place whenever he passed away. That's one way that we can help protect, and it's hugely important, okay? You're not probably going to learn about that online in a do-it-yourself program. We want to talk through these situations with you. What's a strikeout trust? This is kind of my favorite terminology for a kid's subtrust. So instead of just leaving that $1 million to that 10-year-old who's going to get it when they're 18 or 21 years old, let's build in advance a subtrust. I like to call it a strikeout trust. It's either inside of your will or inside of your living trust in writing. You got to set it up, but it springs to life after both of you have passed away. And so that $1 million, instead of going outright to that 18-year-old, here's an example of one way that it could look. There's a lot of iterations, percentage, ages, and stuff. I'm just going to walk through one example. The trustee is going to give the money to your child, or children, whatever. Let's just say one child, for example. Of that $1 million they inherit, they're going to get money for health, support, maintenance, and education. All the things you could kind of think about. Health, co-pays, insurance, hospital, education, public, private, college, PhD, whatever the trustee in their discretion thinks is appropriate based on the size of the trust situation, etc. And then you got maintenance and support, ongoing food, shelter, soccer camps, clothes, you get it, that type of stuff. And then we say, for example, age 23, I call it that postgraduate age, they're going to start getting, say, 3% a year from the trust. 3% on $1 million is 30 grand. So it gives them a great start to life. But it doesn't ruin them. It doesn't disincentivize them from working, right? If you promise me $30,000 for a long time, I'm still going to work because I need more than $30,000. And then we release it in chunks. Let's say they get a chunk at 25, a chunk at 30, and the rest at 35. Let's say at 25, they blow it on gambling and substance abuse and bad decisions. They get another chunk at 30, and they invest in a company because they've got a few years of experience under their belt, and they put it all in this company and it goes belly up. And then that last chunk they're going to get at 35. And so they've already had 2 strikes. They swung and missed. Now hopefully their trustee is going to say, hey, this is your third pitch. There are no more. Make this one count because it's the last pitch you're ever going to get. That's why I call it a strikeout trust. We want to talk through these things with you. You just may not see this in a do it yourself online, and you may not have it in your current estate planning. Oh, by the way, if you have a living trust that was created before the year 2011, there's a good chance you're going to want to have an attorney review that for upgrades, because the way that trusts were drafted before 2011, the typical AB structure, is very different than how I structure trust now, which is more in the disclaimer structure. So if you have a pre-2011 trust, I think it's very important that we have a conversation to talk about upgrading your trust to be more current in line with where the tax law and unified credits are right now. And book. Wills, Trusts, and Estate Planning for Texans, Not Dummies. This is a book I wrote, and I'm going to give you a link for the free download so that you can read it. You'll see some amazing information that we're not even talking about today inside of this book. Get this book, read it. I promise you'll enjoy it. Let's go. Revocable Living Trust. What is a trust? A trust is pretty similar to a will in that it says, when I pass away, here's who gets my assets. You have a trustee instead of an executor. The biggest disadvantage I would say to a trust, probably 2. 1, it's going to cost more money typically. With my firm and most of the firms I know, it's going to cost more to build a trust than to build a will. That's one of the cons of the living trust. And 2, there's some funding, I call it, funding the trust, that you'll need to do to make sure your assets are set up to stay out of probate and either be owned by the trust now or payable to the trust upon your death via a beneficiary designation so that it avoids probate. So those are the 2 biggest drawbacks to a trust in my opinion. Now here's the pros, the benefits of it. It's private. It's a private document, not subject to public disclosure. It's not going to go through the court of law. It's not going to be aired out in the public. It is your private estate. I think you may want to keep that private. A lot of my clients want to keep it private, and a lot of my clients, therefore, want to elect to have a living trust over a will, but it's not for every client. Every situation is unique. We get to talk through these things. If you have an LLC, then it can be very beneficial to have a living trust own that LLC so that the company stays out of probate. Because if that company goes to probate, while you're waiting on letters testamentary, there may be no one to run that company, no one to renew leases, no one to pay expenses. The bank probably won't listen to anybody. I'm assuming, let's say you're running the show, the bank's not going to talk to someone unless they're named on the bank documents already. And they don't have court orders yet, letters testamentary telling them who has the authority to operate on behalf of that LLC. So you're stuck in limbo. Maybe you have tenants, maybe you have clients, maybe you have customers who literally go away because no one's able to operate that company for 2 to 6 months while they're waiting on the court through the probate process. But if you have it owned by a trust, that trustee can step in immediately and start paying bills, renewing leases, working with your clients, finding a buyer, working on an acquisition with someone in that space. So this is very important. What if you have properties? A lot of properties are properties out of state. Then a trust may be very beneficial for you, because if you have property in another state, it's probably going to be subject to probate in that state unless you've taken other measures to avoid probate. Or you can create a living trust, have it own said property in Oklahoma, Colorado, California, etc. And then the trustee can go in and do what they need to do with that LLC, with that property, without having to wait on probate if it's set up properly. It can be more flexible, especially on backup beneficiaries, especially if we do an Exhibit B, for example. So maybe your backup beneficiaries currently are your parents, but if they pass away, you want to name someone else. Well, we can do an Exhibit B that's really easy to change without having to change the entire trust, so it's a lot cheaper and less time consuming. In fact, we can give you an Exhibit B that you can change on your own for $0. So talk to us about that. We'd love to have that conversation with you. Kids nomination for guardianship. So if you pass away, and just want to make sure that you're still listening. We've got the lavalier that we're talking through. I'm not using this headset, but we want to make sure that you're listening because we're going through a lot of important information. We're having fun. So let's do this. Let's keep going. All right. So one of the hard decisions is saying who I want to raise my children if something happens to me. And you're like, I don't know who that is. But if you don't list someone, the court's going to name someone for you. They already have a plan in place. Well, maybe you don't want it to be your brother John because he lives states away and they're going to be uprooted from their current community. Maybe you don't want it to be your sister Sally because she has a completely different religious belief system than you. Maybe you don't want it to be your brother Jack because his political views are completely in contrast with yours. Whatever the situation, or maybe you don't want it to be your brother Danny because you know that Danny looks pretty good on paper. He's got a job. He's never been to jail, but he's just a mean person. He was mean to his kids. He verbally abused them. He verbally abused his spouse. Whatever the situation is, right? He's a gambler. He's an addict. You just don't want him raising your kids. So if you don't say in advance who you want to raise your kids, that's a problem. Go ahead and do this. And I prefer to have this nomination of guardian outside of the will so that if you want to change it, we don't have to go and change the whole will. We just update this document. It's much easier. It's much better in my opinion. That's how I tend to do our documents. So call us for a free conversation. 15-minute free consult, $0, no obligation. We would love to have a conversation with you. Pre-need guardianship, even though you have powers of attorney, we still recommend that you do a pre-need guardianship. And this is telling a court in advance who you want to make decisions for you, who you want to be your guardian, essentially, if you no longer have capacity and for some reason your power of attorney falls short. So for example, child Sally, you got moms in a nursing home. Child Sally keeps going to mom and she visits mom, but for one purpose. She takes her ATM card out, she goes to the ATM, gets her money and puts it back. Sally comes back the next day and pulls out mom's checkbook and says, Mom, sign this check. We need money because we're getting evicted. Boom. Someone keeps taking advantage of mom. Even though you have a power of attorney, you may need to lock down the estate, and that's where guardianship, that's one example of where guardianship may come into play. If you don't say in advance who that person is, that could be trouble. And I see people taking advantage of elderly people all the time, and it's extremely sad. And without planning, it gets even sadder, more sad, because it takes more time, more money, and more fighting. Get this stuff done in advance. We are here. We want to talk to you about this. A living will, also known as an advance directive, states in advance who, if you have a terminal illness or an irreversible illness, for example, you have three options. You can either leave this blank and not fill it out. In that case, your power of attorney, your medical power of attorney agent, assuming you have one, which hopefully after this you will, it's saying, I want them to make the decision. The good news there is they know the facts and circumstances. The bad news is it can be really hard for this person to say, pull the plug on mom, pull the plug on my child, pull the plug on my spouse. That's a hard decision to make. So the second option that you can do is the person in this document can say, I don't want them making that decision. I'm going to make that decision in advance. If I'm in that situation, I want you to pull the plug. So what's the terminal and irreversible illness? It's basically saying this. You're in a hospital. You can't make decisions for yourself. The only reason you're alive is you're on life support, some kind of machine or medication that's keeping you alive, according to medical science. And medical science can be wrong. And medical science is saying that if they withdraw that life support, you're most likely going to pass away in their medical opinion. So you can check a box that says, pull the plug. I don't care what anybody says. And then there's another box that you can check that says, if I'm in that situation, keep me plugged in. I don't care what anybody says, keep me plugged in. There's also some boxes on there that say give me maximum pain relief, even if it hastens my death. Do not give me CPR if I'm in that situation, etc. So there's things to think about, and we can help you with this. And in fact, we offer currently the ability for our clients to get a living will at a reduced price or even free. So contact us, email us, and we can tell you what our current offer is at the moment when you email us. HIPAA release. Oh, and also we have a COVID addendum to a living will that you can have, because I believe that a living will advance directive falls short in regards to COVID. So we have a particular addendum that you can bolt on to a living will, your existing living will, that speaks more to the COVID situation. We do charge a nominal fee for that, so contact us through email or online, or talk to us when you book your free 15-minute consultation, and we can talk about that. I'm telling you, we want to talk to you. Final disposition instructions. So do you want to be buried or cremated? Not really the topic of conversation at Thanksgiving or Christmas, right? So you're not sitting there saying, hey, Bob, look at those Packers. Oh, and by the way, you're going to be buried or cremated. Not really a topic of conversation, especially after you have the turkey. It's like, so, buried or cremated. Maybe you don't care, but a lot of you do. And make sure you put it in writing, because here's a couple situations. You pass away and your kids or your spouse may know, but your kids say, did mom want to be buried or cremated? I don't know. And you really wanted to be buried, but they cremate you. Too late. You can't read. There's no do-overs with this one. What if your kids fight? What if child A says cremation, child B says burial, and they fight? You really want them to ruin their relationship because you failed to put in writing ahead of time what your preference was? So now they're fighting and it destroys their relationship? Come on, it's not worth it. Like I said, estate planning is worth more than just money. It's about money and relationships. Legacy is about your life savings, money, and relationships that you leave behind. Which brings me to my book. Is that? Yes. Legacy Love Letter. Okay? When you pass away, you can leave this behind. One for your spouse, one for each child, one for each of your closest friends. I'm going to give you a couple of examples. It's basically a journal. This one says, I love that you, and you'd fill it out. This one says, you inspired me, and you can fill it out. Here are some of the greatest lessons that I learned in my life. There's lots of these. You made me proud by. I'm sorry that. Right? Imagine having received that from your parent or grandparent, them telling you how much you meant to them. Yes, you have pictures. You may even have videos. But do you have something like this that I would say, my mom, I wrote this recently, and my mom just bought 10 copies, and I'm hoping she'll fill it out and leave me one. I can't wait to receive it from her one day. She told me she's my biggest cheerleader, and that warms me. Sorry, got emotional there for a second. And estate planning is emotional, but that's not the reason to keep delaying it. Get an estate plan in place. We can always update it as time goes on. Beneficiary titling, transfer on death, payable on death. So beneficiary titling trumps a will. So if your investment account says it goes to Bob, but your will says it goes to Sally, the investment account wins and it actually goes to Bob, not to Sally. That can be a good thing or a bad thing. If it's congruent with your wishes, it's a great thing because it can avoid probate. If it's incongruent with your wishes, it's going to someone you don't like anymore, someone who passed away, to an ex-spouse, to an ex-in-law or something like that. We see this stuff all the time. We want to help you with this stuff. Think through this. Yes, it trumps a will, and it even trumps a trust. So you've got to make sure they work in conjunction with each other. It's free to update, which is why I like them. It's easy to do, which is why I like them. But they don't give you as many outs. There's not as much flexibility as you might get with a will or a living trust. So there's pros and cons to using beneficiary designations. You want to make sure you understand how they work. Here's a shoe. You don't even have to leave your house to meet with us. Literally, you don't even have to put your shoes on. Right now, you can just call us. We'll do a 15-minute free, no obligation meeting. If we decide to proceed and you engage us, we'll do another longer phone discussion to discuss and design your estate plan from the comfort of your home, no shoes. And then we can do a Zoom meeting to review your documents, no shoes. And then you can come in and sign them. You'll need your shoes for that one. Or you can hire a mobile notary and have 2 disinterested witnesses come to your house and no shoes. And you can just do it right there in the comfort of your home. We can do all these meetings in person as well, But literally, you can do the entire thing without having to put a single pair of shoes on, or even one shoe, okay? Asset titling is important. Joint tenant versus joint tenants with right of survivorship, very different. Tenants in common. So let's just jump into the number one mistake that I see with homes. Husband and wife own a home, and they think because they own their home jointly that it goes from husband to wife when he passes away. In Texas, that's not true, because the default home ownership in Texas is tenants in common, which means his portion of the estate is his. It goes down to whatever it says in the will, or if he didn't have a will, in accordance with intestacy law. Okay? So right there, you've got probate, and it might not even end up being owned by the spouse potentially. And then it's going to happen again when she passes away. So we can fix that. We can do a transfer on death deed. These came available in the state of Texas a few years ago. And it simply says this. It says it sits right along your side your warranty deed. You got your warranty deed that says, here's who owns it. Now, then the transfer on death deed says, if we pass away or one of us passes away, who owns it? So the transfer on death deed would say, for example, husband and wife own it. If husband passes away, wife owns it fully. If wife passes away, husband owns it fully. If we both pass away, it goes down to, for example, our two kids equally. If one of those kids isn't there, their portion goes to their kids. You get the idea. There's parameters around it. You want to have the name reflective of the name exactly as it is on the deed. You want to have the proper legal description. You got to know that you can't leave it unequally, disproportionately to people. It needs to go equally. So we want to make sure that we have this in place. And I think that just about all, maybe not all, but most Texans need to have two deeds on their property. Their warranty deed and a transfer on death deed. We can help you with this. It's something very simple, but if you don't do it right, it could easily cost you $3,000 to $4,000 in probate fees upon the death of each spouse. And suffice to say, separate property versus community property. Again, we're not going into depths, but you're going to want to understand some of the differences and intricacies, especially if it's a blended family situation. Call us so we can talk through that. The LLC, again, your value in your LLC, pardon me, could evaporate when you pass away if it's not structured properly. And now we get to control. This is my Fire TV or whatever it's called, Fire Stick, I don't know. But it puts me in the control of my TV. You are in control of your estate plan. I can't force you to do it. I can only encourage you to make sure that you have an estate plan that's not useless, but that works. And remember, most of the documents we're talking about are revocable and amendable, can be changed. So you can have a plan A. And if you change your mind, you can go to a plan B. Again, got to have a little fun to keep your attention here. So here's some things to think about regarding Mike Massey Law. So why would you want to choose Mike Massey Law? Well, we have transparent pricing. Our base package prices are listed right on our website. Go check them out on our website, mytxwills.com. MY, that's for my. TX stands for Texas. Wills, WILLS.com. You can see our pricing right there. How often do you see that? You want to see that because you want to have an idea going into it. But how many people actually do that? We do that because we want to go the extra mile and give you the service that we would want from our attorneys. We also have a 3-day guarantee on document delivery. So once you retain us with the engagement letter and the retainer money, and we have all the information from you, we guarantee to have a draft of your estate plan within 3 business days, guaranteed, or we will actually give you a Amazon gift certificate. Okay? That is awesome. I don't know where else you're going to find that these days. 5-star reviews. There are literally hundreds of 5-star reviews on our firm across the internet. Yelp, Google, Avo, Ravala, Nextdoor, you name it. Tons of places you can go and check out and see what clients have said about us. We're not arrogant. We are not arrogant attorneys. A lot of people have a stereotype that attorneys are either boring and dull or arrogant. Hopefully you can see the little goofy side of me. This is not my everyday goofiness, but I'm doing it to keep your interest. We're caring. We're compassionate. I hope that shows. And we're not arrogant. I promise you that. Another advantage to working with Massey Law is you have direct access to the attorney that you're working with. So you don't have to go through a receptionist. You don't have to go through an assistant. You get to go directly to the attorney with phone calls and emails. That is the service that we want to provide. It's literally white glove legal service with a smile. And we have multiple offices throughout Texas. You can look on our website to see where our current offices are at any given time, because this can change over time, but we have multiple offices. We can literally serve anybody in Texas because we can also work remotely with anybody in Texas. So people like us, we help reduce delay and procrastination and anxiety. Get a plan in place that can always be changed. We have a 3-day guarantee, transparent pricing. We're not arrogant, we're fun, we're compassionate, we're caring. But you get to decide for yourself because you are in control. You can't take it with you. If you can afford this, you can afford estate planning. If you're hearing us and you know that it's better to do an estate plan than to cut off your finger, and you know that life is more than just about highlight reels, and you want to make sure that your legacy is solid. And I'm not just talking about your life savings. Yeah, that's important, but we want to help relationships and prepare you as much as possible so that there's the least risk for destructive behavior and relationships on the back end. We want to help make sure that your estate plan is clean and not dirty. You don't even have to put on your shoes for at least a couple of meetings before you sign. And, oh, by the way, here's my family. My wife of 15 years. My son, this is a little older picture, but my son's going into fifth grade now. My medium daughter, Gracie, is in kinder. Our son is, we call them artificial twins because they're the same age, but he's adopted from Ethiopia. And then this little bundle of joy right here is about 3.5 right now. Love them so much. We'd love to talk to you. Now, if you go to this web address, you can collect your free gifts for watching this webinar all the way through. that's bit.ly/Massey free gifts. bit.ly/Massey free gifts. You go there, and just for watching the webinar, we've got a couple of amazing gifts and offers for you. I am truly grateful that you dedicated your time. I promised you would learn something. I'm very, very hopeful that you learned something. I look forward to speaking with you. Collect your gifts there and book a free 15-minute consultation with us here. Cutting your hair with a stapler is useless, and so is a bad estate plan. Call us